Hi, everybody. My name is Amanda Ridding. I consider myself to be an amateur student at law, and I'm making these video shorts for other Canadians in the hopes of helping other people who want to self-represent like myself. I think it's really important. We're not taught any foundation of law in school whatsoever, and I think it's really important that people we start sharing this information so we understand how law works, because until we understand how law works, we're not going to be able to defend ourselves and defend our rights, especially when it matters in a court of law. So today I want to talk about moving the court. And with moving the court, people, once you've established, let's say you've been received a ticket, and I'm working always with the Provincial Offenses Act these days for Ontario, so that's going to be my reference point today. So you've received a ticket, you've established that the act of legislation that governs the ticket is the Provincial Offenses Act. So you've called up the Provincial Offenses Act, and you've established that the character of the person who, first you establish what court has the authority to hear the matter, because you want to understand what rules govern the court. The next thing you do is, of course, you take a look at the character who wrote you the ticket, and you want to confirm whether or not the character actually had the authority under that act or another act to operate under the Provincial Offenses Act. Those two videos I've already done, so if you need more detail, please go back to them. The next thing is you take a look at your ticket, and one of the essential elements of receiving a ticket or a summons is the allegation. The allegation is where they accuse you of something, and then they tell you that this action they're accusing you of here broke this rule over here. Now, here's the problem. Under sometimes these rules on this side have more than one choice. So if they make an allegation on this side and they reference the rule, but they don't reference a subsection of the rule that defines the rule that matches the action over here, that is potentially a fatal error to the summons or offense notice that you've received. And because if you don't know what rule what you did over here, if you don't know what rule over here you're doing this broke, then how can you understand how to defend yourself? And that's the fundamental justice of it. So if that happens, and you've been looking at your ticket done, again, I explained how you read your tickets in another video, and you realize that, okay, they're accusing me of this, and they say I broke a rule over here, but the rule over here is not properly defined. I don't know what rule I broke, so how am I going to do a defense? That's when you go back to the act. So a lot of us, and I have done this myself, folks, and in hindsight, I now realize how come I kept failing and had to always take it to the next level in order to finally win. And I'm not going to go into grand detail here because there's a lot of complicated nuances. But the point is, if you if to receive fundamental justice, a fair hearing, you may need to go to the court to have part or all of the information quashed. I say quashed, not dismissed, not withdrawn. And here's why this has become so important to me. I was helping someone this week, giving them some, just sharing my knowledge again, and it's not legal advice, folks. I'm just sharing my knowledge. And they wrote a motion to dismiss, and they asked me to take a look at it. So while I was looking at the motion to dismiss, I said to them, well, you're doing a motion to dismiss, but to make this more solid, we really should add the rule for the motion to dismiss. Now, I just started sharing my screen in the Provincial Offenses Act, and in the upper right-hand corner, I've already got the word motion typed in. So I'm just going to start scrolling through the act. And when I was scrolling through the act, one of the first things I came to realize is that there's very few rules about motions in the Provincial Offenses Act. And then the second thing I came to realize is that and I'm just going to go back to the beginning of the act because it's jumped me right to the end here, and I want to make sure that I cover this correctly. There is absolutely no motion to dismiss rule. There's no rule for a motion to dismiss. There's no rule for a motion to withdraw. So if there's no rule that is expressed in the Provincial Offenses Act for either a withdrawal or a dismissal, then folks, you can't move the court. The court can only follow the rules. And the court, the Provincial Offenses Act are the rules that the court has to follow. If the rule isn't there, the court can't do it. So if you walk into into an Ontario Court of Justice or the Court of the Queen's Bench, or whatever it's called in another province, and you are there presenting a motion to dismiss, then it will fail. Worse, they're most likely going to give you a dog and pony show, like it actually is a valid thing you're doing, which, folks, is grounds for a complaint to the Law Society of your province. I have a friend who's going to do some shorts for me on that one. We won't go into it. But the point is, if the rule doesn't exist, you can't move the court. So going back, we were flipping through the motions, and I was flipping through. So you can do a motion here to change a venue. If you don't think you're going to get a fair hearing in your hometown, you can get a change of venue to a different to a different court outside of in another town. But you can, and there's other things you can make motions for, but nowhere is there a motion to dismiss. So flipping through this very quickly, and we're almost there. Here we go. So what happens if you have an offense notice or summons, aka a certificate of offense or information, and there's an essential element or an essential procedure component that has not been met? That means it is not clear and regular on its face. That term, by the way, you will find in the Provincial Offenses Act. Just trust me on that. So if you want to take that to the court and say, get rid of this ticket, you don't ask the court to dismiss. You don't ask the court to withdraw. What you need to do is you need to file a motion to quash information or certificate. The motion, what you're asking the court, what the rule that governs the court is this one, Rule 36, Subsection 1. If you want to get the court to fix or get rid of the ticket, then you need to do a motion to quash information or certificate. All right. And rule number 36, subsection 1, an objection to an information or certificate for a defect apparent on its face. Remember, I told you it has to be clear and regular on its face. So for a defect apparent on its face shall be taken by motion to quash the information or certificate before the defendant has pleaded. Now, if the pleading has already come in and you realize after the fact that the certificate is not clear and regular on its face, then, and the plea is in, thereafter you have to have permission from the court, leave of the court, to then do the motion. But if you haven't pled to the court yet, you can file an objection by motion to quash the information for not meeting an essential procedural component or an essential element, which makes the ticket not clear and regular on its face. Now, here's the catch, folks. Don't file the motion until 30 days has expired. And in the case of a summons, because they have 6 months to amend the information, not the summons, the information, since they have 6 months for the information, don't bring it to their attention until the 6 months expires, because they can amend the information within that 6-month time period. So keep an eye on your times. But if the information is not clear and regular on its face, you can do a motion to quash. And then with that motion to quash, the court shall, they have an out here, the court shall not quash an information or certificate, okay, unless an amendment or a particular under section 33, 34, 35 would fail to satisfy. So this is where they can amend it. Watch your timelines. Okay. To satisfy the ends of justice. One of those things, one of those particulars, and I think it's number 5, the court may, before or during a trial, is satisfied that it's necessary for a fair trial, order that a particular further describing the matter. No, that's for the furnishing. So sorry, one of these rules, and I'm not sure which rule it is, but essentially if you ask for it to be quashed, and you have grounds for it to be quashed, they have to quash it. Now they may say, well, they may ask for your consent to continue with the trial, to amend it and continue with the trial. Say no. Once the limitations has expired and you've confirmed and proven to the court that the information or the certificate of notice, certificate of offense is not clear and regular on its face and the limitations have expired, why would you consent to still be tried? Tell them to take a hike. Tell them to take a hike and say, no, they don't have your consent. They messed up, not your problem. Goodbye and sayonara. So I don't remember exactly which one of these particulars it is, but they can't proceed. If statute of limitations is done and it's truly not clear and regular on its face, then they can't proceed without your consent. So don't give them your consent. And I hope that information is clear. As I continue to break down jurisdiction, there's going to be more jurisdiction. I believe I'm going to have to break down. But again, that's why I keep doing these shorts. I hope this information helps. If you have any questions, post them. I'll do my best to get to them. And I don't typically say this, but I'm going to start getting in the habit of saying this. If you think these videos are valuable, please like, subscribe, and share, because all I want to do is get this information out to people so people have a place that they can build a foundation in law so they can better defend their rights if they ever have to go to court. Thank you very much, everyone, and God bless.